Yeah, today Canada drops bombshell for asylum seekers. So we are talking about the new development in refugee determination process in Canada today. Why is it significant and alarming, if I might put it that way? What is meant by Canada drop bombshell for asylum seekers? This is because Bill C-12 has received royal assent on March 26, 2026. I believe that's Friday, last Friday. What's the significance of the bill? Before I move further, what is royal assent? Royal assent is the final step in the legislative process where the Governor General or their deputies sign a bill into law, allowing it to become an act of parliament. So when you see immigration, the instrument of engagement is Immigration and Refugee Protection Act, meaning that it's an act of parliament. So it's the rule of engagement in transacting in immigration process. So why is this one alarming and significant? One, it's an official title. It's called the Strengthening Canada Immigration System and Border Act. This is unprecedented because prior to this, we have the 76 Immigration Act. Then later in 2001, 2002, we have the Immigration and Refugee Protection Act, which now combine immigration as one part and then refugee as another part, which make it more clearer and codified. Unlike the 76 Act that was mainly on immigration rather than refugee. So after that, in 2012, I believe, there was another reform, which was Balanced Refugee Act, which there are a lot of reforms, especially in the asylum process. And 2015 also, there are changes which was called Balanced Immigration Act. So the significance of this new law is that it's going to limit asylum significantly. There are a lot of people that will be excluded, that will be ineligible when it comes to asylum. It's not free for all anymore. It's not issue of floodgate. Canada is known as an humanitarian country for protecting the vulnerable people, people looking for asylum, people looking for protection in any shape or form. But this new law last Friday, March 26, is a significant depart from Canada humanitarian tradition. I will highlight some of it. I believe there might be a lot of criticism and there might be review because it has changed things forever. What I took out from this is that it's one of the most significant change to Canada immigration system in decades. Why do we say decade? We are going to get to the 1985. So if we're talking of 1985 to date now, I believe it qualifies as decades. So in 1985, there are Indians descent that came to Canada, and they had issue with risk to their life, and they were trying to make a refugee claim or seeking asylum. However, at that time, under the 1976 Act, it's codified as Immigration Act, an act of parliament, but refugee was not a significant element of that system. So it was paper-based. You put your, what they call now, basis of claim, you put it in writing, and an administrative officer will make a determination, which is more subjective. One, they didn't see you in person, and they don't feel what you feel. So at that time, there was a legal challenge because you have Charter of Right and Freedom in Canada. So the significant name, you know, Indians, many of them bear the name Singh. So I think there were 7 in number, I can't recall, but they challenged the paper-based decision. As a result of that, they challenged the Minister of Employment and Immigration at that time. That was the designation. It was Minister of Immigration and Employment, not a separate entity, in 1985. So they challenged it and questioned the fundamental right that they have, that since they've been in Canada, the Charter of Right and Freedom extend to any human being that is in Canada. So therefore, they're entitled to right to be heard rather than right to be read, because it was a paper-based application, and it's mostly subjective because the officer will review it and make a determination at that time. So it was only immigration department that was existing in Canada. There was no refugee, immigration and refugee board. There was no Canada Border Services Agency. Everything has to do with immigration, making refugee determination, making immigration process, making enforcement, deportation. Everything was under one umbrella, which is an aspect of the Ministry of Employment and Immigration. Therefore, they went to court, and the case went eventually to Supreme Court. So in April 4, 1985, the court unanimously, I can't recall the number of judges, but it was a unanimous decision that in as much as Charter of Rights and Freedom that was brought to Canada in 1982 emphasized that everyone, so everyone means that every human being, your immigration status, it's not a determinant or discrimination of whoever is referred to as anyone, everyone. So therefore, they're entitled to be heard. So they challenge that decision of the administrative officer that is paper-based. You fill a form and put it in, and they challenge it to the Supreme Court, and the court sided with the lawyer that it's true that everyone should include whoever is in Canada. So therefore, based on the Charter, Right and Freedom, which include asylum seeker, meaning that they are entitled to a fair hearing rather than an administrative process that they will be writing. You might have a genuine case, but you could not, or you are unable to articulate in writing, but you are more at ease to speak. And even though if you can't speak fluently in terms of the two languages of Canada, which is English and French, at least if you have an interpreter, you should be able to express yourself, because we are talking of danger to life. Persecution is danger to your life, which is personal to you. And if there is a mistake, it's like flying an aeroplane in the sky. There is no room for mistake, unlike if you are driving a car. So therefore, if administrative officer use a subjective manner and make a wrong decision and deport the claimant to danger, it will be a sorry case. So they took it very serious. They don't know who is lying, who is saying the truth. Therefore, the court now said that they must be given the fair hearing, meaning that they should be afforded the oral hearing in order for them to articulate their claim. And then they will now be determined by an expert after listening to them, providing evidences, and then make a determination. If at that time the decision was negative and they need to be deported, at least they know that they took all precaution to make sure that they got fair hearing and right to be heard based on Charter of Right and Freedom. So as a result of that, it was a landmark decision that changed everything about asylum claim in Canada. And Canada became a leader in refugee determination process. So therefore, you now see the new Act of Parliament that just came out now, that they called the C-12, now reversing what was a landmark in 1985. So the new decision now is directly opposite, erasing what happened in 1985 in a summary snap. So the ruling of that court, the Supreme Court in 1985, some of the instruction are many, but one of them that is significant is that the judges of the decision instructed the Ministry of Employment and Immigration to establish Immigration and Refugee Board of Canada, IRB. It started the decision was in 1985, but because there will be process to get things done, get the building, get the expert in order to make mechanism to make a determination process. The Immigration and Refugee Protection Act was established in 1989, which is, I believe, four years after. So, and the significance of that now is that everybody making refugee claim in Canada have the unique right to be heard rather than to be read from. So that is where the court make a significant decision. It has to be face to face in order for the judge or the adjudicator to make a determination, because if you see somebody face to face, you might be able to appreciate and understand their situation rather than faceless application that was submitted that will not bring any sensitivity. So that is the background of the 1985. But exactly on Friday, the new minister issued a new law that restrict or eradicate or even cancel the oral hearing by bringing selective and restrictive condition to asylum process now. So we'll go into that. I highlight some of the changes that are being introduced now, which technically now is they are trying to eliminate oral hearing. They didn't do it in full, but technically it's 90% gone. One, what is the justification of Bill C-12? The minister argued that is to maintain a fair and efficient immigration system while protecting genuine claimants. So therefore, the mindset is that there are bogus asylum seekers, and there must be a way to deal with them, and the only way is to use efficiency rather than compassion to deal with the process. So the argument is to maintain a fair and efficient immigration system. The question is, as the previous 1976 Act, 2001-2002 Immigration and Refugee Protection Act, 2012 Balanced Refugee Act, and the 2015 Reform Act have not been fair and efficient? That's the question. So therefore, the law changes everything about how protection claims are processed now. Previously, you come to Canada or you are inside Canada, you make a claim and you have right to be referred to Immigration and Refugee Protection Board, except if there are exclusion under Section 98, which is rare in most cases, except you violate or commit crime against humanity. So most cases, or 99%, have eligibility to be referred to Immigration and Refugee Board, which is a specialized agency with skill and knowledge to determine who is a refugee, who is not a refugee, based on the 1951 Convention that highlighted 5 grounds to make a refugee claim, or Section 97 that stipulated person in need of protection. Because in 1951, the problem then were highlighted on under 5 grounds. However, they foresaw that human beings are dynamic, so there might be changes in circumstances and world order. So they now introduce, if you don't qualify as a convention refugee, you might be considered as a person in need of protection. So that's why they have Section 96 talking about the convention refugee, and the Section 97 talking about person in need of protection. For example, people who are being trafficked were not anticipated in 1951. So that's part of the people that could be considered as a person in need of protection. So if you go for refugee hearing and your case is going to be accepted, the decision would say you are accepted as a person in need of protection or a convention refugee. So they don't make that distinction, but they are the same. It's more of semantic, but it's just dynamism to make sure that protection is offered to those who are really in danger. So therefore, it will fundamentally reshape who can be eligible for asylum claim. You remember in 1985, they said anybody in Canada who seek asylum or who seek for protection because their life is in danger should be eligible to be heard. Either the claim is going to be successful or not, it's another thing, but you have right to be heard. But this one now is bringing restriction: who can be heard, who cannot be heard. So they created the bill, which is Bill C-12, created 2 criteria for eligibility. This was not there until Thursday last week, which is March 25. Since the last 40-something years, this change now came on Friday. So it might be a Black Friday if you want to classify it as Black Friday. So the first eligibility now is that asylum claims made more than 1 year after June 24, 2020 will not be eligible to seek asylum, regardless of whether the person has since left and returned to Canada. Why do they do this? Like I said last week, immigration always reflects habit. They track habit of immigrant, visitors, students, or asylum seekers. If you look at June 24, 2020, your mind should be reading why that date. We are in 2026. Why 2020? If you look at that time, that would be during COVID, when many people were in Canada, were trapped in Canada, and Canada was liberal at that time, that many people got 10 years multiple visa, 5 years multiple visa, depending on the expiration of your passport. That's why what the visa officer will use to make a determination to give you the length of stay. So many people that have multiple entry is not a status in Canada. It's just a privilege to knock at the door of Canada anytime within that 10 years to avoid inconvenience of submitting your passport at the visa post every now and then when you want to come to Canada. So as a result of that, there are a lot of people that came during that period and they went in and out. Some abused it, some did not abuse it, some don't know what to do, some that had problem in their home country during COVID, just stay in Canada and feel safe or feel economically secure. So as a result of that, they introduce in Canada, usually if you have job offer, you're supposed to go outside and apply. But during COVID, because it was an unusual circumstances, it was circumstances beyond everyone's control, they issue in Canada work permit. So many people enjoy that and some people abuse it, but depending on what the immigration is looking at. But before they make a decision, they will always track habit and behavior. So they now saw that many people coming in, going out, not using that visa for what they came to do. And some might be going through expiration because COVID is over now, but they still have a valid visa that can go in and come in. They might now want to use it to make a refugee claim as a strategy to look for immigration status. That's why the law was retroactive, saying that first, asylum claim made more than 1 year after June 24, 2020 will not be eligible to seek asylum, regardless of whether the person has since left and returned to Canada, which is what I was saying. If you've been using your multiple in and out, and now it's about getting expired, maybe it's 5 years, maybe it's 10 years, or you don't know what to do again, you now say, okay, the only way is make a refugee claim. Now they are trying to make that impossible. That's one. And that's why I talk about last week about one thing you should not do in Canada, ensure your status is always active in Canada. Irrespective of your strategy, maintain your legal status while planning for what you want to do. So the second eligibility barrier now that exists since Friday that the bill has been consented to is that people who enter Canada through the Canada-US land border must, it's not should, must make a refugee claim within 14 days now. If it's 15 days, you are ineligible. So if you come in through US now, immediately you enter Canada, you must make a claim before expiration of 14 days. It must be within that 14 days. However, it doesn't mean that your case will be rejected. It's just that you are ineligible to proceed for oral hearing at the Immigration and Refugee Board. Okay? So, what will now be the option? They will give you pre-removal risk assessment. So if you remember when I was talking about the historical context, that in 1985, the administrative process of using form and writing a story without being given the opportunity to see the decision maker, just submit the form and wait for the decision. Exactly the same thing with the pre-removal risk assessment. Pre-removal risk assessment, it's not the first line of action for protection. It's the last, when everything has failed. Your refugee claim failed, your appeal failed, your judicial review failed, and then before you are being deported, they give you pre-removal risk assessment. You are removal ready. However, we don't know. Maybe between the time your case was refused at the refugee board, your circumstances might have changed, that you did not qualify as a convention refugee or person in need of protection, but you might now face risk of return to your country. So the officer will give you a form to fill. You submit within the 15 days, first one. The second one will now be another 15 days, which will be 30 days. So the first 15 days is just to give your biography. You, how, why, and then the next 15 days is for you to articulate your case and then provide supportive document so that it's a danger to your life. They took it serious that we might thought you did not fit in with the technical definition of a refugee. However, your life might be in danger. It might be because you lack the technical know-how to articulate your case. So Canada was very humanitarian and compassionate in nature. But this is a clear departure. This is more of economic consideration now trump humanitarian consideration. Efficiency trump humanitarian consideration. Value for life, value for dignity. You must live, because to seek an asylum and refer to Immigration and Refugee Board is very costly to process one case. Even if you are lying, it might cost between $5,000 to $20,000 or more to process one case. So which it's why the efficiency is coming in, that they believe there are a lot of bogus refugee claimants, especially students who don't know what to do after their graduation. Maybe their work permit expire, not renew. They came in without proper guidance and there is no way out. The only option, most of them, is bad advice, make a refugee claim. So they want to try and curtail this with this legislation. So going further, both restriction, we talk about one. The first one is asylum claim made 1 year after June. The people who have been here June 24, 2020, which is about 6 years ago. Okay, or those coming through the border, because many, especially Nigerians and Ghanaians, came in 2018 through the US border en masse, that Quebec really was overflown with resources that they had to cry to the government for the federal government to assist. So everybody just coming through New York, Buffalo, some people through Minneapolis, Winnipeg, all here and there. But now that the minister had to go to Nigeria and talk to the visa office in Nigeria, but there was no answer. They were still coming en masse. I remember in 2018, yeah, I had an appointment with the visa officer. I think she came from Abuja. So we discussed in Lagos and she told me that, oh, that more you see your people, even people with 2 years, multiple visa UK, 5 years, multiple visa US, they still, I give them benefit of doubt that they will go and come back. They still arrive in Canada and make a refugee claim. So it was so alarming in 2018. So they are trying as much as possible now to foresee such in future and curb it. That's why this is coming up, but I'm not too sure this will stand, because it's too restrictive. It's a direct opposite of what Canada is known for, in my respective opinion. So thousands of people, so both restriction, which we talk about coming through US or staying 1 year before you make a claim, both restriction apply to all claim made on or after June 3rd, 2025. So you see the confusion now. They're talking of last year, June 3rd, 2025. The assent came in the March 26, 2026. So that was why I was advising last week that don't make a refugee claim through getting bad advice from your friend or from previous refugee claimants that were successful. Ensure you make consultation so that what works yesterday might have changed just today. This is exactly what this is. Somebody who made a claim on Thursday now is different from somebody who made a claim on Friday with this legislation, because it's very restrictive in nature. I've studied it and I'm still studying it, but it's going to exclude a lot of people. It's going to encourage a lot of underground, because people will prefer to stay underground rather than being fined ineligible. So therefore, since they are talking about that, we now look at the rule applied to all asylum claims made on or after June 3rd, 2025. So meaning that this new law did not apply to anybody that made claim prior to June 2nd. If you make your claim June 2nd, 2025, this did not apply to you. But if you make it on June 3rd, 2025, you will be ineligible for being referred to Immigration and Refugee Board. It's not that you are not going to make your claim, but you are now going to make your claim in an administrative manner rather than face to face. You know, when you see somebody that need help and you have somebody who is ready to assist you, if they see you assess your condition, they might be sympathetic with you and assist you. But if you just send a letter or note to somebody, I didn't see you, I don't know, I can't imagine who is asking for help. So I don't just make a subjective decision either based on my feelings rather than based on objective. So it's more going to be more subjective when you start referring people to pre-removal risk assessment. Pre-removal risk assessment, like I said, was the last step. Now it's going to come as the first step, which is very alarming. The 1 year rule looks back at entry after June 24, 2020, which is why I'm saying you need to seek for consultation and clarify. There is a lot of interpretation before you shoot in and get in rather than being excluded. So that if you are going to make an asylum case and you know it's going to be pre-removal risk assessment, then you will have gotten all your documents, or you will have been sure that you will be able to present very viable, convincing, persuasive, supporting document, rather than shooting yourself in the leg and say you are going to get this, you are going to get this, and they give you 15 days or 30 days to provide the document. You are unable to provide the document and they will refuse you. Unlike the refugee face-to-face hearing, even when you don't have document, you might explain your situation why you don't have the document. Maybe you call your country, the people you know, they did not respond, they didn't send it, or it's coming in the mail, or it has not arrived. Whatever reason, they will listen to you. But this one, nobody is going to listen to you. And many people that will not be able to articulate or be able to use the legal instrument to make their case, is going to be a big problem, because the pre-removal risk assessment ordinarily acceptance rate is very, very low, significantly low, maybe less than 10%, because it's very difficult to show that there is risk to your life which was not available at the time you are coming. But if you are going to then you know the oral hearing at the refugee board is clearer in the sense that you have the itemized criteria that you are either a convention refugee based on the 1951 Convention Instrument of Determination, which means that your life is in danger. Basis of your claim is your religious, based on your religious faith, you are being persecuted. Based on your nationality, who you are either a Palestinian, a Jewish, or you are a Turkish, born in Iraq, the northern Turkish, which have conflict of nationality, or your race, which we talk about too. You might be a Jew, you might be a Palestine, you might be a combination of father, mother, Jew, and Palestine. So it's difficult to distinguish your race. And then you have the public political opinion. You might be persecuted because you are criticizing government in your home country. Those are clear-cut basis of your claim. And then the person in need of protection is based on Convention Against Torture. So anything that constitutes torture under the Torture Convention will be considered by the judge. But the pre-removal risk assessment now is not going to be considered by a judge. It's going to be considered mostly by the enforcement department. And since 2023, after September 11, immigration enforcement has been carved out of immigration and moved to Canada Border Services. And their mindset is enforcement, deportation, danger to the public, danger to the society, no justification, leave Canada. And there is budget for that. And they have to justify how many people deported, why, how. So those are the people that is going to make the determination that somebody who is or who used to be compassionate was making before. So it's going to be very, very rigid and selective. So I have feelings that it's going to be reviewed. There is no way this will stand the test of time, because it's going to be too restrictive for many people to qualify for protection, which is against the Canada tradition generally. Furthermore, the bill also says if you first enter Canada after June 24, 2020 and wait more than 1 year to file an asylum claim, you will not be eligible. So there are a lot of people here now that came during COVID. That was 2019 and 2020. So they came, they were here, they were not able to travel. So invariably, they were excluded automatically because 1 year has passed since June 24, 2020. No matter your circumstances now, 1 year gap has passed. So it's either you leave even if you face danger. So he now said that if you enter, like I said, through US, after the 14 days has passed, even if it's 15 days, either you are sick or something happened, you are unable to submit within 14 days or initiate the claim, then they will refer you to pre-removal risk assessment. So that is that, like we talk about. So the retroactive entry date, which is unusual, that you are now referring to 5 years for somebody to be ineligible to make a claim. And we're talking of people's life, people's liberty. It's going to be controversial. I can bet this. So by and large, apart from this now, we're talking of the restriction of making the claim. That's one. So the efficiency also go beyond refugee eligibility now. What this bill also says, when I read, is that apart from Migration 5, you know, there is Migration 5. Those are 5 countries that share information. New Zealand, Australia, UK, Canada, and US. If you apply for visa in any of those countries, if you are applying to any of them in future, you have to disclose everything because they share information. If you lie, they will know. So now, apart from that now, this bill go beyond that. Those are sharing information with other countries. But now, in addition to sharing your information around the world, they are now going to be sharing information within Canada, which means that immigration will now share personal information with the federal agency, depending on any agency that you want to deal with, provincial, territory, and government partners. So now, it's going beyond immigration. It's now getting into personal document, that your document now is shared among all agencies in Canada. So meaning that there is nowhere to hide. So it's very, very, very restrictive. Immigration can now share identity, immigration status, any immigration issue document with other government agencies. Before, they will ask for your consent. Now, without your consent. So, people running to another province because of lack of sharing information easily. Anywhere you go in Canada now, you are in open field. So that's another aspect of the bill. The concern, like I said, I have concern too when I read it. The advocacy group have raised concern that the pre-removal risk assessment process provide fewer procedural protection than a full immigration hearing, particularly for vulnerable claimants who may struggle to present their case without an in-person appearance. Like somebody who can't speak proper English, somebody who is vulnerable, maybe they've been tortured, they've been abused, and you now tell them to put their story, to put their concern, their help in a paper manner. The woman's feelings will not be there. They might have a good case, but there is no way to articulate and touch the mind of the decision maker. And most of the time, the Immigration and Refugee Protection, the Immigration and Refugee Board judges are well trained. They have technical knowledge to determine credibility. But pre-removal risk assessment now is not focusing more on credibility rather than risk. And the definition of risk is different from persecution, because asylum claim was based on persecution, not risk, because not every risk constitutes persecution. In 1951, when they sat down in San Francisco in California in the United States, it was because of the Second World War that the Jewish were being targeted to eliminate them. So they now sat down and say, how do we prevent future occurrence? So persecution must be personal, but every risk may not be personal. There might be general risk. For example, if you come to Canada and say kidnapping is rampant in your country or in your place of origin or habitual residence, they are not going to protect you in Canada because that's a general risk. But if you say, for example, a woman that says and her husband wants to abuse or is abusing him or you want to kill him or whatever, just one person, they would assist you and consider it persecution. But under the pre-removal risk assessment now, it's ambiguous. There is no clarity. There is no checklist. If the border control officer, whose mindset is trained to deport, to enforce, is going to make a determination, there will be element of bias and people's rights, life will be in risk. Sorry, will be at risk, I mean. So, and then the vulnerable ones, the unaccompanied one that are coming minor without any parent, how will they be able to articulate their case in pre-removal risk assessment? Unlike before, when they have a designated representative that will take them to oral hearing and the judge will see them and then make an assessment and determination and provide the necessary protection. But in this context, it's going to be difficult, in my opinion. Also, even the UN, they've issued a report saying that the bill could make life harder for asylum seekers because some people may no longer get a full refugee hearing to express their case orally. You remember we talked in 1985, the Supreme Court said every person in Canada who is physically present and is everybody, meaning every human being, have right to be heard. So this is going against Charter of Right and Freedom. So basically, it's going to definitely will be challenged on the constitutional ground. On charter rights, I can bet that, especially Section 7. So many people will not have right to be heard again. Even if they are going to say some nonsense, they still hold the privilege to be heard and hear what they want to say. So above all, like I said, the way I see this is a significant shift. Like US, this was happening in US before, but it's unimaginable that it could happen in Canada. So it's a significant departure, in my opinion and submission, from the Canada humanitarian tradition of offering protection for the persecuted and the vulnerable one. Because I remember 2003 in Winnipeg, we issue a report card when the 2001-2002 Immigration and Refugee Protection Act was assented to. Yeah, we issued a report card. I was part of the member of the team under the Canadian Council for Refugee. So the report card was able to extend protection to many people who need protection. But now this is going exactly opposite. It's now being restrictive and being draconian in terms of protecting people. So in my opinion, I humbly submit that it will not stand. There must be review, there will be review, and there will be court case challenging the constitutional right of the bill. Although government law is the law, but since Canada immigration, especially the administrative law, is entrenched in the procedural fairness and transparency, this will be challenged, in my opinion. I predict, I hope there will be common sense and this will change. It's a really bombshell for asylum seekers, especially people who really need it. You cannot commonize or assume that everybody is a bogus refugee. There is no perfect system, but at least because some people are abusing the system doesn't mean those who really need it should not be protected. Thank you for your time. I will be talking about, in lieu of this, about the Nigerian-UK asylum agreement that was signed, I think last week, next Sunday, so that we understand the importance of that, and then it guides us better. The more we know, the better we do. Thank you for your time.